Thanks, Cheryl. I love how you make us both tall and fast. I've been called worse, so yeah, we'll take it and run with it. So yeah, as Cheryl was saying, after a long career of teaching legal writing, training all sorts of judges, uh, lawyers at firms, lawyers at governmental agencies, writing books on the topic and the like, I did take the plunge into legal tech around 2017. And what I wanted to do early on was just take a lot of the teachings, a lot of the things that people said help them, and try to automate the whole thing so that you have this sort of one-stop shopping for all things legal writing and legal editing. So we actually launched our first version of BriefCatch in 2018, which seems like a lifetime ago. And we're now in our third version, cloud-based version. We have, as I'll show you in a little bit, we have about 11,700 different ways of improving legal documents, and all the things that sort of drag things down for lawyers and judges, from errors that other tools aren't going to catch, to kind of higher level problems with transitions and flow and having punchier, more vivid language. We've also tried to make it a sort of self-training and development product. As you know, it's not so easy anymore to get attorneys to go to formal training, the kind I used to do. So one of the things I've worked hard on the last couple of years is trying to make it so that people within their workflow, as they're doing their daily work, meeting their billable targets and whatnot, are actually learning as they go. In the UI, you'll see we've got all sorts of examples from famous lawyers and judges, explanations, and then for the really ambitious lifetime learners, we have links to all sorts of content, articles I've written, parts of my books, and the like. So again, one-stop shopping for all things legal editing. People use it at the beginning of the process as they go along. And of course, when the stakes are high, right before they file an important document or submit it up the food chain to clients or supervisors. So probably the best thing, especially for those of you who haven't tried it yet or seen it, I've just got a motley crew of actual sentences. So we train. Everyone trains these days. Everything is training. We're no exception. We train our tool on actual lawyer and judge work products. And I'm not talking about drafts. I'm talking about published work product with all sorts of issues and errors. And that helps us all the time stay ahead of the curve. Again, trying to enable people to catch as many things as they can confidently without getting distracted by all this minutia, so they can spend their time instead on strategy, structure, and big picture thinking. So as I said, I've given you a bunch of sentences here, and I'll try to do track changes so you can get a sense of how this works when you're under pressure, when the stakes are high. There are all sorts of scans. While I was talking, it's very, very fast. You can put a 200-page document, as I did the other day, and it's going to still be able to scan it in seconds. And what I want to show you is the UI gives you choices. I will often give you choices. Some people just kind of realize a light bulb goes off and they click on something they like. Other people like to ponder. It's very important for lawyers, I've learned, to make sure people feel like when they're using legal tech, they're still in control, that it's actually refining your voice, it's not replacing your voice. And that's one of the reasons we really let people stay in the driver's seat, look at different options as they're trying to improve things, pick the one they want, and then it's made for you immediately in track changes. So this is a pretty good example of something that people have trouble with. I won't get into all the usage issues here, except to tell you that the original sentence is incorrect. Grammatically, you need a subjunctive, you need that with requested. Again, some people like a more casual style, ask the court to hold, that would be at least correct. Some people are more traditional, they realize that the structure is wrong. That's enough for many people under the gun, but as I've said before, let's say you're curious, you want to learn more, you want to see it in action. Now we've got 3 examples, 2 from Supreme Court justices, 1 from a prominent employment lawyer at a top AmLaw 100 firm, and you can see all the changes in context. So that could be to learn, could be to be inspired, but it can also help you decide which of the options is best. Okay, so I'm going to play it safe here and pick what I know, because we track these things. About 71% of lawyers who see this particular rule pick the second option, and I'll do that as well. Okay, so just imagine you're moving along, all sorts of things come up, things slip through. This is one of these kind of more, I'd say, kind of higher level problems. In a way, you're lucky if this is the kind of writing issue you're worried about, but actually determine does not take if. In formal legal writing, it should take whether. And we've got, Wachtell-Lipton report, Justice Thomas sentence showing you that as well. We move along to kind of, the bane of the existence of many lawyers, things like citations, blue booking, formatting rules. There's a punctuation error here you can see. This is the kind of thing very hard, of course, when you're tired. You've looked at the document many times, very hard to catch these things manually. There we go. And just in case people want to be reassured, we do have an example from Justice Sotomayor of the proper semicolon there. So I'll show you that. This is another error, same firm's document. Again, this would pass spell check, but this is not correct. In RAID, the rate should be lowercase. We'll fix that. We have a reporter error here, F sup. Now we're up to fourth, right? But this is third and it's incorrect. We'll get that fixed too. We have, again, we fixed 7 things in about 5 seconds. This is another kind of higher level problem. Conformance with is actually not accurate here. I'll take a step back, by the way, because of course, I've tried to go 5 minutes without saying AI, but now I'll say AI because everything is AI. So one of the really great things in the last 6 months, we now have like massive amounts of data on what the most renowned performers in the profession do. So if you see conformity to, it's not just that I think conformity to is better than conformance with. I do think that, but I don't care what I think. It's because in the top performers in the profession, they're going to use conformity to about 10 times more often than conformance with. Okay, so you're getting that kind of trust that is so important when people use tools that touch their most coveted possession as lawyers, their work product. I'll show you a few more things here. Again, higher level problems. This is the wrong preposition. This is something I saw, actually a Supreme Court justice made this mistake the other day. Not one of the ones who uses the product, clearly. Dissimilar should be to, not from. Imputed should be, well, I'd say computed should be to here. Let's say you want a little variety though. Okay, so we've learned when people try to make this point, actually sometimes what they're really trying to say, trying to help people think of what they really mean. So what they're really trying to say is not imputed to, or certainly not imputed upon, which isn't even correct, but let's say attributed to. Okay, so we move on. More wording issues, another wording issue. Now we have a legal idiom. People like to fight about this kind of thing. Is it okay to say per? And again, it's not a moral judgment. It's analysis of what the top legal writers do. They don't use per before contracts or statutes, but we give a choice, right? You want to be more modern, you use under. You want to be more formal, pursuant to. And if you're not sure which one sits better with you, you've got a nice menu array here of options to inspire you. That's another mistake. This is another mistake. Now we have one of these things people tend to argue about, like when do you say assert, when do you say allege? Obviously, Grammarly, Microsoft Word they have no idea. You actually, though, in this case, are not supposed to say that you allege claims. You're supposed to allege facts for causes of action or claims. We need assert, fixes that. This is, again, if you're lucky enough to write about the Chief Justice, I guess you have this kind of problem. This is the kind of thing, very, very hard to keep track. Even the greatest, most devoted lawyers can't remember all these details. It's actually not the Chief Justice of the Supreme Court, but the Chief Justice of the United States. And it's also not the Delaware Chancery Court, but the Delaware Court of Chancery. Okay, we've got idiomatic edits. We have, as here, ways to be more modern, less legalistic. We have ways of ensuring consistency in parentheticals, so you don't actually need the finding here, according to the Blue Book. Same thing with stating. We have a word here that's superfluous. Now we have a phrase that's superfluous. Another phrase that's superfluous. People say, cut, be concise, but what do you actually do when you have a 20-page draft? This is 3 in a row, 4 in a row, 5 in a row, right? Every one of these redundancies, we've got a blue booking error, another grammar mistake, and a common typo. Okay, so I have got a lot more. We actually, as I said, have 11,500 of these. But what I want to get across is the diverse ways that a product like this can help a lawyer just when the stakes are the highest, because so many of these things don't jump off the page in the way people want, no matter how desperate they are to find them. And what happens is if you let the tool sort of do this kind of work for you, not only are you saving a lot of time that you can now spend on substance and strategy, but simply making it much easier to get these changes done without labor, without typing, without kind of unneeded eye strain. What it does is it gets you to kind of focus on the other words, the other phrases you've written as well. So you're actually kind of allocating your editing time itself to the best purposes. Okay, so a few other things that appeal to different constituencies that are not pure editing I want to share. Then I want to tell you about our latest AI product, and then we'll go to questions. So right now, in the profession, you have lots of concerns about retention, the job retention, lots of concerns about morale, and also lots of concerns about fairness. So of all the skills that people have in firms, I can tell you from having done it for better for worse for decades, the one that makes people the most sensitive tends to be writing. So when people get criticized for writing, it tends to really, really throw them for a loop. It's something that people are very personal about. And for those reasons and others, we have some kind of interesting tools if you're into making evaluation and progress and even kind of morale more objective and predictable. Okay, so one thing we have is these AI-derived scores that actually compare your document to the work of the very best lawyers and judges on 5 different axes, and then kind of turn the numbers and pop out these 5 metrics. And some people don't like that kind of thing, but I'm sure most lawyers are quite competitive. And one of the really fantastic things I'm always happy when I hear this is because it's kind of like an individual sport, like golf, people actually feel like they're competing with themselves, and they actually get a sort of morale boost or adrenaline boost watching the numbers go up on a particular document as they edit, but even more important, watching them gradually on average go up over time. Okay, so that's one. And then another is kind of the kind of feedback or mentoring piece. Okay, these are also common complaints, especially in law firms, right? I don't get any feedback anymore. I don't have any mentoring. All the partners do is complain, change things. We also have reports. And what the reports do is they take a look at your whole document and they look for trends. So they're not just looking at these individual issues as we've been doing. They look for patterns in your writing that you might not be aware of. And we have always strengths, always positive things. And then we always have things you can work on. It doesn't matter if you're Scalia or Kagan, you're still going to get strengths and you're still going to get things that could be even better. And because again, these are algorithm based and they're external, they tend not to threaten people's ego the way human criticism can often do. So even more than when I created these, I've found in this particular era we're inhabiting, that kind of objective measure and reporting is really, really appreciated, not just by the people who are supervised and on the younger side, but by their supervisors as well. So I want to tell you, I have a video clip, but I want to tell you kind of like the next phase for BriefCatch. Okay, so we too, like most vendors, are on the AI bandwagon. But what we're finding is, especially for a written work product, you need that moat of subject matter expertise, and you need someone who is trusted in the profession for writing before lawyers are going to, let alone judges, are going to take the advice. So our first product, which I'm really excited about, is called Client Catch. So a huge pain point for many lawyers, especially those who bill their time, involves those kinds of updates and alerts that you need to publish. If you're a firm, you have to publish them on the site, and of course they're non-billable. But also all the different lawyers who have to update their clients day to day on whatever's going on at the SEC, the FDIC, the courts, and whatnot. So what we did is create a product that lets you upload any kind of source material. So let's say there's a proposed regulation, there's a new statute out there, maybe Congress has passed it, maybe it's in committee, maybe there's a new case, maybe there's a new order, there's a regulatory guidance, and you just tell our tool a couple of things about your audience. Like, I represent banks, and they're really concerned about Sarbanes-Oxley fines, and it will instantly take that source material, put it through the process I've devised, and out comes a fully formatted client alert with a heading, with next steps, bullet points, hyperlinks to secondary and primary sources and other resources. Okay, so this is kind of our next phase. It's of course very exciting. We also have taken care to make sure that all the digested material is accurate without any hallucinations. That's kind of part of our secret sauce. And we're also rolling out a bunch of other products in a series just like that. I can't say too much about all of them, but I'll tell you about one. We are actually working on a really, really exciting product that takes fact statements or fact sections and in 8 different ways turns them into a much more compelling and persuasive narrative. So it will actually figure out the persona of the main corporations or parties that you describe. It will figure out whether those are benefiting you if you're the plaintiff or the defendant, and how they relate to your theme. And then it will recast the facts to make them more flowing, more convincing, but also to sound particular themes that in the draft form are often fairly latent in the fact section. We improve the chronology, we create headings, we create good conclusions, all sorts of things like that really take the most challenging types of legal writing and get them to the next level.